Next up, we'll be talking a little bit about Switzerland. We have Dr. Evelyn Thar and Riccardo Gosteli from the Advanced Metrics, which is an online marketing and analytics consulting company, and they focus obviously a lot about on digital marketing and digital marketing compliance. Dr. Evelyn Thar is the CEO of Advanced Metrics, and she's also a lecturer for all of these topics that she will cover now: digital marketing, analytics, data privacy. And along her side will be Riccardo, who is advising clients in finance, health, education, and e-commerce sectors, and has an IT background. And like I said, they will be talking about Switzerland and the upcoming new Data Protection Act that will come into place on the 1st of September. And they will tell us what happens, how it differs from the GDPR, and how companies can prepare themselves for it. Welcome on stage.
So, hello everyone, and thanks for having us today. Thank you for the introduction, Nina. And as you already heard, we're the Swiss delegation here, and we're here to talk to you about Switzerland, the new Data Protection Act, and also the situation we have in Switzerland right now. So, Nina already said a little bit about Advanced Metrics. We're an agency in Zurich. Where else in Switzerland? We are founded in 2013, and we are specializing in online marketing, analytics, and also data compliance. We started with data protection in 2018 because of GDPR, of course. Yes, I don't have to say anything about us. Nina also covered that. We have a small agenda. We planned to talk about the new Federal Act of Data Protection. So it's the official name. I want to give you the timeline, why now, and then also tell you what's new about the Data Protection Act. And also, because we thought that may be interesting for you, if it's also applicable for companies outside Switzerland. And then Ricky will talk about the 5 steps to data privacy readiness. And maybe it sounds familiar to you, but for all our Swiss clients, it's really something they have to step up now. So why now? Why on 1st of September we have the new Data Protection Act coming into force? Our Data Protection Act is really old. It's from the 92. So that was before the internet. And this came into force in 93. We had a partially revision in 2008, also a long time ago. Then we had a first draft of the new Data Protection Act in 2017. So that was even before GDPR. We tried to do it. But then we realized, or the Swiss government realized, that it's too much. So there was just a partial revision again for the so-called Schengen FADP. So it was just for the police to exchange data. And then already in 2020, the FADP was ready. We had to wait a little bit for objections. And then it was mentioned in 22 that we have 1 year, and then on 1st of September 23, the new Data Protection Act will come into force. There is now a transition period, so we have had this year now, and on 1st of September, we shoot directly. So why do we need that now? I think it's obvious, because Switzerland needs to comply with the EU. So we want to make sure that the EU recognizes Switzerland as a third country with an adequate level of data protection. And also, we want to exchange data, also cross-border. So that's why we need the law really urgently. So what's new? Also here, you will see it's familiar to you, because it's very close to the GDPR. In Switzerland, only data of natural persons are protected by the FADP. We also have the two principles, privacy by design and privacy by default. And then we have the so-called EDUP. This is the Eidgenössische Datenschutzbeauftragter, and he's called the Data Protection Information Commissioner in English. And he now will need to investigate all breaches of this law ex officio. This is very new to us. And also he can order injunctions. This is also very new to us. So far he could also only give recommendations. And that's it. So his power is bigger now, and this is really good. Then what you also know already from GDPR, we have the right to disclosure for data subjects. And then maybe smaller detail, but not to all of the companies, the data you're collecting needs to be portable. So what does that mean for companies? We also need a list or a register of all activities regarding data processing, but only for companies with more than 250 employees. This doesn't mean that all smaller companies don't need that. There are excuses. Because if you're collecting data, personal data, and you do that on a regular basis, you also need this register for companies which are smaller than 250 employees. Then our new Data Protection Act is very precise about the privacy policy. It's really detailed what you need to have in there. So you need to list all data processing activities and also mention the countries you transfer your data to. This is not so easy in every case, because we all know the tools. They say, yes, we can store your data worldwide. And yes, that's not working for the new act in Switzerland. So you really need to know where your data is stored. Then for all cross-border transfers, you need these standard contractual clauses. You also know that. And a big difference to the GDPR is that we only need an information and notification policy. So notification policy means if you have an automated process, for example, for issuing credit cards, you have to notify the user that the approval of a credit card or the denial was an automated process. And information policy needs, you only need to inform your users about your data processing. So there is no user consent in our law, which is a big difference to the GDPR. But now what happens? We discuss a lot with different lawyers, and as you all know, if you talk to 3 lawyers, you have 5 opinions. And the lawyers in Switzerland are now debating, what does that mean, information only? Is it sufficient to only have a data privacy policy and have all the information in there? Or do you need a cookie banner and give this information in the cookie banner? And if you have a cookie banner, can you just close it? And now we have this new trend towards, no, that's not enough. You also need consent for marketing cookies, because these 2 principles, privacy by design and privacy by default, they're so strong that this would mean you need the consent at least for the marketing and targeting cookies. So these are big discussions. Nobody knows what's really happening, because our EDUP, the Information Commissioner, he didn't speak up so far. So we don't know. So what we tell all our clients is, be prepared. Do at least something. And to have a cookie banner just for information doesn't hurt anyone, but you did at least something. You see, we're very pragmatic in Switzerland. You also need a deletion policy. That means the data needs to be deleted, but you can choose after how many years or months you want to do that. You're totally free. You just need to have a process. Also here, I would say, Switzerland, we're very pragmatic. Then you need to have an impact assessment for every data processing you need to have this impact assessment in terms of data protection. You also need to inform the Information Commissioner in every case of a data breach, and this is really mandatory. And then the fines in Switzerland, they're a little bit lower than in the EU, so they can only go up to 250,000, but there are on individuals, big difference here, which means the fine does not go to a company, it goes to the responsible person of this company. So this means usually president of the board or CEO. And then 250 is maybe not such a small amount. So are companies outside of Switzerland affected? Yes, they are. Because if you process data of persons living in Switzerland, this new law is also applicable to you. And there is a second thing. If you do this data processing on a regular basis, I mean, if you're offering goods and services in Switzerland, you do data processing. Think of an online shop where you can order things in Switzerland. You also ship to Switzerland. You do it on a regular basis. That can be the case that you need a representative in Switzerland or a representative office. Also here, you see, I'm very vague because it's all very vague. It's just the lawyers think it could well be that you need that, but it's not really clear because we have to wait. We have to wait until 1st of September comes. We have to wait if the ADAP speaks up. We have to wait until we have a real lawsuit and then we know. So now, after all these illegal things, I hand over to Ricky and he tells you what we or how we consult our clients to be data privacy ready.
Yes, so 5 steps to data privacy readiness sounds super simple. It's not usually. So what we start with is like a data scheme where we try to figure out what tools is a company using, how do they collect data, what data are they collecting. And that's most likely to be the most complicated part because companies don't know. So we have a lot of talks with different people, with responsible people of different tools, platforms, and so on. And we try to answer these questions and just get the current status of how they deal with data. And then we basically have a checklist of how to be compliant with our Data Protection Act. Of course, this also applies to GDPR. We can use the exact same processes. So it might be interesting for the Europeans as well. And then we have the status, what needs to be done, what's good, what's not sufficient. And step 4 and 5 would then be finding the gaps and evaluating tools that replace existing ones which are not compliant, or maybe adjusting setups so they are compliant. Sometimes there are contracts missing and such. And then we have to implement those changes together with the client and third parties. So if we look at these 5 steps, the first 3 ones are just creating this document of documentation. Most likely in European countries, you did this for GDPR reasons already. Maybe there is still some company which did not. In Switzerland, most companies do have absolutely no documentation about how they are dealing with their data. So for us, it's a big deal right now. So in the first step, which we call data discovery, as mentioned, we are looking for tools, any kind of tools, web analytics, CMS, databases, offline data processing as well, if they send digital data to a print service, for example, to distribute catalogs or magazines or whatever, to see if there is actually a contract between those parties, if whatever they are doing with the data is compliant. In the data analysis, we are trying to figure out, okay, are they using personal data? What data are they using actually? How are they using it? And do they need it? I mean, that's a question we heard a lot also yesterday. Do companies actually need the data they're collecting, or what do they actually want to do with that data later on? So it's an interesting process to talk with the companies, because they start to really think about their data strategy thanks to this data scheme that we are doing with them. And then we do this check. We will have a look at, do they have a process for deletion of data? What happens if any subject wants their data to be deleted? Can they actually do it or not? Do they have a privacy policy, which is fine? Of course, here also we have the CMP, which we are checking. Although, as mentioned, in Switzerland, this is not, right now it's to be discussed or to be seen what's happening there. But most Swiss countries obviously also have to comply with GDPR, because most Swiss countries somehow also have business relationships with Europeans. So this gives us then this document with all the information on data processing activities, so this list or register that Evelyn talked about earlier. And then we go to these data privacy gaps. And here our main interest is really to find the best solution for the client. It's not about selling any tool or whatever. We just want to fill those gaps in the best possible way. And this again means a lot of discussions with the companies in what they are looking for, what do they want to achieve in the long term. And then evaluating those tools, and maybe we can just adjust the setups, as said before. Maybe we need a different tool. Now here we're doing a lot of web analytics, so there's some web analytics tool. There's so many solutions out there that can be set up in a compliant way. Another topic that comes up regularly in terms of web analytics, of course, is server-side tracking, which also allows for full data control. Also in Switzerland, we see a small but steady trend that companies want to be in control over their data. It's really small and really slow, but it's coming. We hear it more regularly. And yeah, I'm sure you all know about the CNIL in France, that they specifically mentioned server-side tracking to be a solution also for Google Analytics to be compliant if it's set up correct. Now, this obviously needs some technical expertise and resources also to maintain such a server-side setup. So a quick excursus to that from an agency perspective. We are mainly working with Google Server-Side Container and the JENTIS platform. And for us, it's really important to find the solutions which fit the clients best. So it doesn't have to be server-side tracking. It can be Matomo, it can be whatever. It just needs to fit into their budget and needs. And for example, Google Server-Side Tracking is more an implementation that you would do if you have a lot of internal resources and know-how. It's not something I would recommend doing completely with externals only, because the support from Google, if the relationship with the agency breaks or whatever, is not there. So you kind of have to get into it, and it's rather complex. There's not many templates. You have to take care of the server infrastructure and so on. And with JENTIS, the big advantages, obviously, for companies is that the server infrastructure is just given. And we as an agency can say the support is great. So thanks to the organizer at this point. And there are also some templates that you can use already, which is not the case for a lot in GTM. And also there are a lot of connections to different tools and also CMPs. So that's some quick notes on server-side tracking. And then if we figured out, okay, what are the tools that we need to replace, what are these gaps, we really go into discussions with the client. We again ask them, many times with different tools, do you actually need that data? Maybe a more pragmatic solution would do it as well. And then we also need to look at costs and resources long term so they can maintain that system that they set up. And then we basically implement it. And what we do as an agency, this varies a lot. Some companies do the implementations themselves with lawyers, agencies, and so on. And we just did this concept. And of course, many times we also work on that implementation. We set up new tools and update them if necessary and possible. And yeah, when we are done with all of this, you should be privacy compliant in Switzerland and also in the European Union. That's it from my side. Back to Evelyn.
So then we have the key takeaways, and we're really right on time. We have 18 seconds. So the new FADP is similar to GDPR, but not the same. Small differences, but obviously, if you're prepared for GDPR, you're very well prepared for the FADP. It also applies to companies outside of Switzerland. And the third point is very important. There is no transition period. So 1st of September, then it starts and then it comes into force and then you have to be data privacy ready. So thank you for your attention. If you have questions, we are here now. And I think also Nina prepared some questions. And do we have a few minutes before lunch, before everybody heads out?
Yes,
Okay.
like no one's leaving, right? No one's leaving. Let's just move a little bit further down. Yeah, perfect. Okay, so I have a question for the audience first. Who of you is doing business in Switzerland? So who of you will be affected by this? Quite a few. Mm-hmm. Nice. So, does anyone have questions? All clear. Everyone prepared. 1st of September. It's happening over there. Mike is coming. Margot with the mic.
Thank you very much. It was a very nice wake-up call for everyone, I think. You mentioned that a DPIA is required for the processing activities. Is that to say that there is no threshold, so literally for all processing activities? A DPIA is required under the new law? That's my question.
You want to go? Should I go?
As far as I know, there is no threshold. But as mentioned by Evelyn, we have to see what the EDUB is actually suggesting and what they're actually realizing when we have the law. Unfortunately, in Switzerland, that's the way it is right now.
Thank you. I mean, I understand that you counsel your clients to prepare, but on the other hand, if it's that vague, would everyone just do all of that work if possibly it's not needed?
Yeah, it's a very good question. You have to find a good a middle way to do something, as she said before, just do something, because the law will be there and it is possible that there will be individual fines.
Okay, thank you. So the defensible position is actually just to do some paperwork so that you can show that you've been aware of this and,
yes,
and not be blank-handed. So that's the overall advice, yeah?
Yes, and I think it's also a very good preparation for the time when you actually know what's going on. So you already have everything documented and kind of set up. So it should be an easier process at that point then.
Maybe to add here, it sounds like, oh, we are so vague in Switzerland, we don't really take it serious with the Data Protection Act. That's not the case. I think it's a really good way to give all companies the possibility to do something in this direction. But we don't have hard thresholds, hard levels and everything. So we just want everyone to take care of data protection, data privacy. And in Switzerland, we don't have a tradition of handing out fines like this. So that's why we have this information commissioner. And what he will do is he will tell you that you have some data privacy breaches, that you need to do something. And then you have time to fix that. So we really don't have a tradition of fine here, fine here, fine there. you know, we're Switzerland, we're good at very diplomatic, very neutral.
So
Thank you very much.
Max Schrems has no case in Switzerland.
And not that I know of.
And more questions here.
I think Europe always can learn a lot from Switzerland because you have proven for many centuries that you stayed out of conflicts and so on. So I think we're always good advised to look at what you're doing in Switzerland. I find one point very interesting, and forgive me, I missed your first 3-5 minutes. You may have covered it there. This issue with the liability. We heard in the past 1.5 days a lot about it needs management attention and C-level involvement, chief data officer. And in Switzerland, there is this explicit statement of the liability, the private liability of managing directors for this change. Can you share a little bit more how you expect that to happen? Because it could be the wake-up call for the management, and the organization always needs a wake-up call coming top-down.
I think it's a very good principle. I mentioned it. It's like you just described it. It's on individuals. The fines are on individuals, but it's up to 250,000. There can be cases where you see that the data processing was not handled right by a data protection officer, for example. Then there is the possibility to give smaller fines of 50K or so. But yes, it's on individuals, and it's always the management responsible of the company. And this would be mostly the president of the board. And also here, I think it's a very good concept, because if it affects me personally, I make sure top down that everything is handled right. So nobody can hide behind the company, because it's me personally that I'm responsible.
Thank you.
Do you think that Switzerland is doing a better job than the EU with the GDPR?
So we had 5 more years to collect data than the EU. That's great. No, just kidding. Swiss usually like to wait and see what's happening around. So I'm not sure if it's better. It's different, of course. We will see. I mean, we have to wait until this law is actually here and what the realization will look like. So not a very clear answer.
All right. Nevertheless, an answer. Thank you, Riccardo and Evelyn.
Thank you.
Thanks.